The news hit the nation like a jolt, a moment that would be remembered for years to come. Across living rooms, offices, and city streets, Americans paused, their attention captured by a headline that felt both historic and deeply personal. In a rare and unanimous 9-0 decision, the Supreme Court declared that your digital life is your private life. For the first time, the highest court in the land recognized that the information we create, share, and store online deserves the same protection as the papers and effects in our homes. On a crisp December morning, the justices reset the balance of power between citizen and state. Their ruling was clear: the government must now obtain a warrant before accessing your personal data. This was more than a legal technicality. It was a fundamental shift in how privacy is understood in the digital era. For years, Americans had grown uneasy, sensing that their phones and devices were quietly tracking every move, every message, every search. Outdated laws, written long before the internet, failed to keep pace with technology, leaving millions vulnerable to surveillance they never agreed to. The Digital Privacy Alliance, a coalition of passionate advocates, tech workers, and everyday citizens, rose up to challenge the government's unchecked ability to collect user data from companies without a warrant. Their fight was not just for themselves, but for the rights of every American. In court, they argued that our digital footprints, our locations, our searches, our emails, our social media posts, are the modern equivalent of diaries and letters, protected by the Fourth Amendment. They insisted that privacy must evolve alongside technology. The government countered, claiming that by sharing data with companies, we had surrendered our right to privacy. But the court rejected that argument outright, affirming that constitutional rights do not vanish in the digital world. The reaction was swift and electric. Privacy advocates erupted in celebration, tech companies welcomed long-awaited clarity, and legal experts hailed the decision as a turning point for civil liberties in the 21st century. Ordinary people, from families at home to students on campus, realized that their digital trails, their memories, conversations, and daily routines were now constitutionally protected. Relief and hope spread as people understood the magnitude of this new safeguard. The court had drawn a new line in the sand, creating a digital curtain of privacy around every American. This was not just a symbolic gesture, but a powerful new reality. This wasn't just a legal update. It was a national reckoning with what it means to be private in a world that's always watching. It forced a conversation about the boundaries between public safety and personal freedom, and about the kind of society we want to build. The decision forced the country to confront the reality that our lives are mapped, tracked, and stored online, and that those maps, those digital records, now have the full weight of legal protection behind them. The ruling didn't just change the law, it changed the relationship between Americans and their technology. It reminded us that our devices are not just tools, but extensions of our private selves, deserving of respect and protection. Overnight, the digital world became a place where privacy is not just a hope, but a right, where every login, every message, every search is shielded by the Constitution. The Supreme Court's message was clear and unwavering. In the digital age, privacy is not negotiable. It is a fundamental right, as essential as any other freedom enshrined in the Constitution. The digital curtain is now drawn by the Constitution itself, and with it, a new era of digital independence begins for every American. Before this landmark ruling, digital privacy was a confusing maze, full of dead ends and uncertainty. For most people, understanding how their information was used or protected felt nearly impossible. Every website, app, and service seemed to have its own rules, and the average user was left to fend for themselves in a world that was changing faster than the laws could keep up. The third-party doctrine, created in the 1970s, established that you lost your right to privacy the moment you shared information with a company or service provider. This legal idea was born in an era of rotary phones and paper records, not the digital age. Back then, it mostly meant phone numbers dialed or checks written. But today, it means every click, every search, every GPS ping, and every message you send online, an endless stream of personal data. Law enforcement agencies took advantage of this loophole, gaining access to massive amounts of digital data with just a subpoena, no warrant required, and often with little oversight or transparency. Outdated laws like the Electronic Communications Privacy Act of 1986 offered only weak and inconsistent protections, failing to keep pace with the explosion of digital technology and the new ways we communicate. For ordinary Americans, there was no clear sense of their rights. Privacy policies were dense and unreadable, and most users clicked agree without ever understanding the risks or what they were giving up. The old world assumed constant surveillance, putting the burden on individuals to protect themselves, even as technology outpaced their ability to do so. People tried to shield themselves, but the system was stacked against them. The Supreme Court's decision changed everything. It flipped the script. Now the government must justify its intrusion into your digital life, rather than you having to prove your right to privacy. Your digital life is no longer an open book for anyone to read. You have the power to lock it, to control who sees your information, and to demand accountability. The patchwork of weak protections is gone, replaced by a clear constitutional shield that stands strong in the digital age, finally bringing clarity and security. Privacy is no longer a privilege for the few, but a protected right for everyone, woven into the very fabric of our digital lives. At the heart of this debate is the Fourth Amendment, promising security against unreasonable searches. Written in 1791, it protected homes and papers. But what about emails and smartphones? Data isn't physical, it's stored on distant servers, copied in an instant. The government argued broad access was needed for public safety, but privacy advocates warned of a surveillance state. The founders couldn't imagine a device tracking your every move, but the spirit of the Fourth Amendment was clear. Protect personal autonomy. The challenge was to apply an 18th century right to 21st century technology. The court's answer: digital data deserves the same protection as your home. Liberty and security can coexist if the law evolves. The digital dilemma is now a constitutional guarantee. United States versus Digital Privacy Alliance began quietly, but its impact was seismic. The alliance, lawyers, engineers, and citizens challenged the government's use of the third-party doctrine for digital data. The government argued data shared with companies was a business record, not private. The Supreme Court justices pressed both sides. Is your digital history like a bank record, or the contents of your home? The alliance argued digital participation isn't voluntary, it's a necessity. Our data is an extension of ourselves, not just a business transaction. The justices saw that old analogies no longer fit. The soul of the Fourth Amendment was at stake, and the court chose to protect it. The digital age demanded a new definition of privacy, and the court delivered. This decision stands on the shoulders of landmark privacy cases, each one building a foundation for the next. Over decades, the Supreme Court has slowly shaped the boundaries of privacy in America, responding to new technologies and changing times. In 1967, Katz v. United States established that the Fourth Amendment protects people, not just places. The case involved police wiretapping a public phone booth, and the court declared that what matters is the person's expectation of privacy, not the physical location. The reasonable expectation of privacy became the test, a standard that would echo through future cases and shape how courts view privacy in an evolving world. In 2014, Riley v. California recognized that smartphones hold the privacies of life, requiring a warrant for searches. The court acknowledged that our phones are more than just devices. They are repositories of our most personal information. Carpenter v. United States in 2018 extended this to location data, but only narrowly. The court ruled that police need a warrant to access historical cell phone location records, recognizing the sensitive nature of tracking a person's movements over time. The Digital Privacy Alliance case took these precedents further, applying their logic to all digital data. For the first time, the court considered the full scope of our digital footprints: texts, emails, photos, and more. The court reasoned if your phone and location are protected, so is your entire digital existence. Every message, search, and digital interaction deserves the same constitutional shield. No more piecemeal exceptions. This was a comprehensive doctrine for the digital age. The ruling unified privacy protections, closing loopholes, and setting a clear, modern standard. The law finally caught up with reality, reflecting how people actually live and communicate in the 21st century. The digital mosaic of your life is now constitutionally shielded. Every piece of your online identity, from social media to private messages, is protected from unreasonable search. The court moved from small steps to a giant leap, transforming privacy law for a new era and ensuring that rights keep pace with technology. Privacy law is no longer stuck in the analog past. The shift is profound, marking a new chapter in the ongoing story of constitutional rights. The digital future is now protected by precedent, giving every American confidence that their private digital world is finally recognized and safeguarded by the highest court. The Supreme Court's ruling sets a bright-line rule: the government needs a warrant to access your digital data. Law enforcement can no longer use broad subpoenas for fishing expeditions. Police must now show probable cause to a judge before accessing your search history, location, or cloud files. This means more focused investigations and a cultural shift in policing. For tech companies, the ruling brings clarity. They can refuse government requests without a warrant. Now, they're not just data conduits, but guardians of user privacy. Companies must strengthen legal teams and challenge overbroad warrants. The front line of constitutional rights has shifted to Silicon Valley. The era of unchecked digital surveillance is over. For everyday Americans, this ruling is a game changer. Your digital trail, searches, locations, messages, is now protected by the Fourth Amendment. You can use technology without fearing government surveillance at every turn. The law now treats your digital life like your home, private, by default. But remember, companies still collect your data for business. The ruling limits government access, not corporate collection. Stay vigilant, use privacy tools, read policies, and be mindful online. This isn't a magic fix, but it's a powerful foundation. Your digital life is now yours, by right, not by luck. In a divided era, a unanimous Supreme Court decision is rare and powerful. 9 justices across ideologies agreed digital privacy is a core constitutional value. This isn't a temporary fix, it's a strong, stable precedent. Lower courts, law enforcement, and Congress now have clear guidance. The unanimity signals that privacy transcends politics. It restores faith in the judiciary's role as a guardian of rights. Some principles are so vital, they unite even the most divided institutions. The 9-0 ruling is as important as the privacy it protects. The Supreme Court's decision is a milestone, not the finish line. It sets a constitutional floor for privacy, but leaves many questions open. The ruling limits government access, but not what companies do with your data. The next privacy battle is in Congress, which must craft comprehensive data laws. Issues like data use, sharing, and deletion remain unresolved. Courts will keep interpreting the boundaries as technology evolves. The conversation between law and tech is ongoing. Privacy debates will shape the society we become. The ruling reasserts privacy's value in the digital age. Americans now have a stronger footing as we face the future. Our digital lives are, at last, our own.